The following information, material, and content is covered under fair use. This is for training and educational purposes only, for teaching and commenting in a classroom setting. Again, this is for training and educational purposes only. This does not constitute tax advice, financial advice, nor legal advice. If you need any applicable advice, please seek competent counsel. Do your own due diligence, regardless of who presents the information. All rights, titles, and actions or interests reserved ab initio without prejudice. Hey everyone, this is B with To Be Fruitful Training Group. All praises to the Most High. And today we're going to be covering why securitization is legal. Now, we're going to be reading out of a paper entitled Securitization is Illegal by Michael Nwogugu. Please forgive me if I butchered that. He's a CPA out of Maryland. He went to City College of New York. He has an MBA from Columbia University. He attended Suffolk Law School out of Boston. And I believe he's more than qualified to speak on the matter of the tax implications and the antitrust and RICO violations in regards to the securitization process. Now, out of his abstract, quote, under U.S. laws, securitization is illegal primarily because it's fraudulent and causes specific violations of RICO, usury, and antitrust laws. Securitization of many types of assets, loans, credit cards, auto receivables, intellectual property, etc., has become more prevalent, particularly for financially distressed companies and companies with low or mid-tier credit ratings. This article focuses on securitization as it pertains to asset-backed securities, ABS, and mortgage-backed securities, MBS, and analyzes critical legal and corporate governance issues. Under U.S. laws, securitization is illegal. Indeed, many authors have illustrated the deficiencies in securitization. This article focuses on securitization as it pertains to asset-backed securities and mortgage-backed securities. The existing literature on legal and corporate governance issues pertaining to securitization is extensive, but has several gaps that have not been addressed at all or sufficiently. Whether securitization is legal, whether securitization causes usury, the standards for usurious loans or forbearance, the specific components of cost of capital for purposes of assessing usury violations, antitrust liability in securitization transactions, federal or state RICO liability in securitization transactions, constitutionality thereof, the validity of contracts used in effecting those transactions, whether securitization usurps the purposes of the U.S. Bankruptcy Code. This article seeks to fill these significant gaps in the literature. Although the following analysis is supported with U.S. case law, the principles derived are applicable to securitization transactions in common law contracts and civil law countries. In analyzing the legality of securitization, the following criteria are relevant: origins and history of securitization, legislative history, evolution of securitization processes, and current practices. Carlson, 1998, Janger, 2002, Lupica, 2000, traces the history of securitization to direct and specific efforts or collaborations to avoid the impact of U.S. bankruptcy laws. Klee and Butler and other authors have traced the history of securitization to attempts to handle the problem of non-performing debt. Types of contracts used in securitization. The key criteria for enforceability. Purposes, wording, and scope of applicable laws, state contract laws, state trust laws, U.S. Bankruptcy Code, and state or federal securities laws. The legislative intent of the U.S. Congress in drafting and revising the U.S. Bankruptcy Code. How the applicable laws are applied in securitization processes by market participants, regulators, and lawyers that represent investors. The people, markets, and entities, organizations affected by securitization, the usefulness of any existing, possible, and proposed measures designed to reduce fraud, crime, or misconduct, transaction costs, and the results and consequences of application of relevant laws. Securitization violates state usury laws. Securitization violates usury laws because the resulting effective interest rate typically exceeds legally allowable rates set by state usury laws. There is substantial disagreement, conflicts in case law holdings among various U.S. court jurisdictions, and also within some judicial jurisdictions about some issues, and these conflicts have not been resolved by the U.S. Supreme Court. On these issues, even the cases for which the U.S. Supreme Court denied certiorari vary substantially in their holdings. The issues are as follows. What constitutes usury? What costs should be included when calculating the effective cost of funds? What types of forbearance qualify for applicability of usury laws? Conditions for preemption of state usury laws. Where securitization is deemed an assignment of collateral, perhaps an assignment of interest. The effective cost of funds for the securitization transaction is not the advertised interest cost, investor's coupon rate, of the asset-backed security, but the sum of the following. The greater of the sponsor's or originator's annual cost of equity in percentages, or the percentage annual cash yield from the collateral in a situation where the special purpose vehicle's corporate documents expressly state that the excess spread should be paid to the sponsor. The excess spread should be subtracted from the resulting percentage. The excess spread is defined as the gross cash yield from the collateral minus the interest paid to investors minus the servicing expense paid to the servicer minus charge-offs, impaired collateral. It's essential to note that a special purpose vehicle, especially with the context of House Joint Resolution 192, Public Law 73-10, and Richard Nixon's suspension of the dollar from the gold standard, or the convertibility to gold in 1971, effectively makes all contracts trusts, as there's no valuable consideration. And when dealing with special purpose vehicles, you're dealing with, again, trusts. And another important note is that charge-offs are considered impaired collateral. So were you aware that any charge-offs on your accounts were considered impaired collateral? Continuing. The amortized value difference. The difference between the market value of the collateral and the amount raised from the ABS offering before bankers' fees, which is then amortized over the average life of the asset-backed security bonds at a discount rate equal to the U.S. Treasury bond at the same maturity, and then expressed as percentage of the market value of the collateral. This difference can range from 10 to 30% of the market value of the collateral and is highest where there is a senior or junior structure, and the junior or first loss piece serves only as credit enhancement. All, quote, true sale, disguised loan, and assignment securitizations are essentially tax evasion schemes. In the U.S., the applicable tax evasion statute is the U.S. Internal Revenue Code Section 7201, which reads as follows, quote, any person who willfully attempts in any manner to evade or defeat any tax imposed by this title or the payment thereof shall, in addition to other penalties provided by law, be guilty of a felony, and upon conviction thereof shall be fined not more than $100,000, $500,000 in the case of a corporation, or imprisoned not more than 5 years, or both, together with the costs of prosecution, end quote. Under this statute and related case law, prosecutors must prove 3 elements beyond a reasonable doubt. The actus reus, the guilty conduct, which consists of an affirmative act and not mere omission or failure to act. The mens rea, mental element of willfulness, and the attendant circumstance of existence of a tax deficiency and unpaid tax liability. In the case of true sale transactions, the tax evasion occurs because A, the sponsor determines the price at which the collateral is transferred to the special purpose vehicle, or perhaps trust, and hence can arbitrarily lower or increase the price to avoid capital gains taxes. It's assumed that the sponsor is a profit maximizing entity and will always act to minimize its tax liability and to avoid any tax assessment. B, the sponsor typically retains a residual interest in the special purpose vehicle in the form of interest-only securities and principal-only securities and junior piece, which are typically taxed differently and at different tax basis compared to the original collateral. Hence, the sponsor can lower the price of the collateral upon transfer to the special purpose vehicle and convert what would have been capital gains into non-taxable basis for tax purposes. In the special purpose vehicle, residual. C, there's typically the requisite intent by the sponsor, evidenced by the arrangement of the transaction and the transfer of assets to the SPV. D, before securitization, collateral is typically reported in the sponsor's financial statements at book value, lower of cost or market under both U.S. and international accounting standards. Loans and accounts receivables are typically not revalued to market value unless there has been some major impairment in value, which does not reflect true market values and results in effective tax evasion upon transfer of that collateral to the SPV, because any unrealized gain is not taxed. The actus reus is manifested by the execution of the securitization transaction and transfer of assets to the SPV. The mens rea, or specific intent, is manifested by the elaborate arrangements implicit in securitization transactions, the method of determination of the price of the collateral to be transferred to the special purpose vehicle, the objectives of securitization, and the sponsor's transfer of assets to the SPV. G, the unpaid tax liability consists of foregone tax on the capital gains from the collateral transaction is structured to avoid recognition of capital gains, and tax on any income from the collateral which is, quote, converted into basis or other non-taxable forms. Now, something very essential to note is that this is the reason why people are even looking to even become liable in the eyes of the IRS as far as capital gains tax or income tax, because people need to know the difference between income versus compensation. Income is derived from capital gains via the stock market or one of the markets, and compensation is derived directly from the labor or goods and services of someone, an individual, namely. Again, that's not legal advice nor financial advice. There's quite a bit more due diligence, but that is something that people need to understand. H, income from the collateral that would have been taxable in the sponsor's financial statements is converted into non-taxable basis in the form of the SPV's interest-only and principal-only securities, part of the interest spread. The difference between the SPV's income and what it pays as interest and operating costs is paid out to principal-only security holders, and this transfer forms interest into return of capital or just capital repayment with no tax consequences. In the case of, quote, disguised loan or assignment securitization transactions, the tax evasion occurs because A, the sponsor determines the price at which the collateral is transferred to the special purpose vehicle. And to illustrate, what is a special purpose vehicle, SPV, and why do companies form them? A special purpose vehicle is a subsidiary created by a parent company to isolate financial risk. It is also called a special purpose entity. Its legal status as a separate company makes its obligations secure even if the parent company goes bankrupt. A special purpose vehicle is sometimes referred to as a bankruptcy remote entity for this reason. These vehicles can become a financially devastating way to hide company debt if accounting loopholes are exploited, as seen in the 2001 Enron scandal. A corporation might use an SPV to undertake a risky venture while reducing any negative financial impact on the parent company and its investors. The SPV may also be a holding company for the securitization of debt. SPVs have been used by companies to hide financial losses. A parent company creates a special purpose vehicle to isolate or securitize assets in a separate company that's often kept off the balance sheet. It may be created to undertake a risky project while protecting the parent company from the most severe risks of its failure, or solely to securitize debt in some cases so investors can be assured of repayment. What investors are they talking about? Are they talking about the parent company's investors in the SPV? It's unclear what it states. A company can form the special purpose vehicle as a limited partnership, a trust, a corporation, or a limited liability company, LLC, among other options. It may be designed for independent ownership, management, and funding. SPVs help companies securitize assets, create joint ventures, isolate corporate assets, or perform other financial transactions. Continuing, and hence can lower or increase the price of the collateral to avoid capital gains taxes. B. The sponsor typically retains a residual interest in the special purpose vehicle, which is typically taxed differently and at different tax bases compared to the original collateral. Hence, the sponsor can lower the price upon transfer to the SPV and convert what would have been capital gains into non-taxable basis for tax purposes. C. The transfer of collateral to the SPV and the creation of interest-only and principal-only securities essentially converts what would have been taxable capital gains into non-taxable basis. D. Any gain in the value of the collateral is not recognized for tax purposes because there has not been any, quote, sale. E. Where the asset-backed security is partly amortizing, where you have a mortgage or a lien, any capital gains are converted into interest payments. The payment coupons and interest coupons. F. The actus reus is manifested by the execution of the securitization transaction and transfer of assets to the SPV. G. The mens rea, or specific intent, is manifested by the elaborate arrangements implicit in securitization transactions, the objectives of securitization, and the sponsor's transfer of assets to the SPV. H. The unpaid tax liability consists of tax on the capital gains from the transfer of the collateral. The transaction is structured to avoid recognition of sale, whereas the transfer to the SPV is effectively a sale, and tax on any income from the collateral which is converted into basis or other non-taxable forms, IOs and POs, by securitization. So we have quite a number of companies and larger businesses that are essentially taking and stealing using language fraud based on, the grant, whether the implied grant under misrepresentation from the principal investors in their companies, and essentially giving a measly, you'll somewhat get paid, or you have the hopes of getting paid, but if the collateral does not perform, or there's no interest derived from it in that specific manner, especially with the way that they're converted to off-book, entries, they essentially reduce those liabilities and, essentially defraud the investors of those interest payments that, upon redemption are supposed to be paid out. However, it's very easy to see that typically with, redeeming those interest coupons, these companies and larger businesses are very reluctant to honor those and exchange the monies of account to monies of exchange for any given transaction. They're very reluctant. In all true sale, disguised loan, and assignment securitizations, the conflict of interest inherent in the sponsor also serving as the servicer constitutes fraud and conversion. In most securitization transactions, the sponsor eventually serves as the servicer of the special purpose vehicle asset pool. As servicer, the sponsor A determines when there has been an impairment of collateral, and B selects collateral for replacement. C monitors collateral performance. To prove fraud, prosecutors must prove several elements beyond a reasonable doubt. Actus reus is the misrepresentation of material facts. Mens rea is the intent to misrepresent the sponsor or servicer's acts. Truthfulness and objectivity, fairness is manifested by the dual role of the sponsor or servicer, which constitutes a conflict of interest. The reliance element. ABS investors rely heavily on the structure arrangements, contract and disclosure statements in securitizations, which are relatively complex. 4. The victim suffers loss as a result of their misrepresentations, direct or proximate causation. Investors suffer losses because the sponsor or servicer's misrepresentations of its obligations, fairness and objectivity, and fiduciary duties. In all true sale, disguised loan, and assignment securitizations where the special purpose vehicle is a trust, the declaration of trust is void because it's for an illegal purpose. The declaration of trust relating to the SPV is void because the intent and purpose of the SPV is illegal and unconstitutional, as described in this article and in Inwogugu 2006. Again, please pardon any butchering of the name. Don't speak that language. Off-balance sheet treatment of asset-backed securities, both true sale and assignment transactions, constitutes fraud. Under present accounting rules in the U.S. and most countries, if certain criteria were met, the debt raised by the SPV in securitization can be treated as an off-balance sheet debt. But this requires compliance with 3 criteria. The SPV should be truly independent from the sponsor and of the directors, fiduciary administrative duties notwithstanding. The sponsor's transfer of assets to the SPV should be a true sale, and the sponsor should not have any ongoing economic interest in the assets. And 3, the form and substance should be transparently identical, and the structure should not appear to be illusory or deceptive. They've been recently revised, you can see here. The off-balance sheet treatment of ABS debt and securitizations constitutes fraud because the mens rea to misrepresent the trust nature of the SPV debt is manifested by the elaborate arrangements and structure of the securitization transaction. The actus reus consists of the affirmative act of the misrepresentation of material facts by not consolidating the SPV on the sponsor's balance sheet. The reliance element. The sponsor's current and prospective shareholders and other investors rely heavily on the structure or arrangements of securitizations, associated disclosure statements, and assurances of off-balance sheet treatment of SPV debt in securitizations, which are relatively complex. These form the primary source of knowledge and valuation terms for the investor. The victim suffers loss as a result of the misrepresentation. It's essentially language fraud and securities fraud. All true sale, disguised loan, and assignment securitizations involve fraudulent conveyances. Any transfer or conveyance of the debtor's assets that is deemed to be made for the purposes of hindering, delaying, or defrauding actual or potential creditors may be determined to be a fraudulent conveyance. In the U.S., 3 sets of laws cover potential fraudulent conveyances. Section 548 of the U.S. Bankruptcy Code, or most states have adopted the Uniform Fraudulent Transfer Act, or the older Uniform Fraudulent Conveyance Act, or C. Fraudulent transfer claims can also be made under a theory of constructive fraud, in which circumstantial evidence may warrant a finding that fraudulent transfers were made with the primary purpose of shielding assets from current or future creditors. Although each state has its own laws regarding the appropriate elements of proof of constructive fraud, Section 548A2 of the U.S. Bankruptcy Code permits an inference of constructive fraud if the following factors exist. The debtor received less than reasonably equivalent value for the property transferred, and 2, the debtor either was insolvent or became insolvent as a result of the transfer, retained unreasonably small capital after the transfer, or made the transfer with the intent or belief that it would incur debts beyond its ability to pay. Intent to hinder, delay, or defraud creditors. Originator's transfer of assets to SPV. All true sale, disguised loan, and assignment securitizations are fraudulent conveyances as defined in the U.S. Bankruptcy Code and Uniform Fraudulent Transfer Act, because the originator or sponsor's mere act of transferring assets to an SPV reduces the values of any of its unsecured creditors' claims, i.e., trade creditors, holders of unsecured loans, holders of certain preferred stock, etc. Without such transfers, unsecured creditors would have had access to such assets. This is sufficient evidence of intent to hinder, delay, or defraud existing creditors. Intent to hinder, delay, or defraud creditors. Originator's transfer of assets to SPV is not done in arm's length transactions. The originator's transfer of assets to the SPV via a true sale or assignment is typically not done in arm's length transactions. Most originators have substantial influence or control over the valuation of collateral, the selection of the appraiser's valuers, the choice of appraised collateral, the corporate form and life of the SPV, and the selection of the officers and trustees of the SPV. Hence, the originator can manipulate the values of collateral for accounting and economic purposes. The originator typically creates funds and staffs the SPV, hires the SPV's officers and directors, and determines the SPV's corporate governance policies. The combination of such excessive control and the originator's transfer of assets to the SPV is prima facie evidence of intent to hinder, delay, or defraud the originator's existing and future creditors. Securitization constitutes a violation of federal RICO statutes. In true sale, disguised loan, or assignment securitizations, there are fraudulent transactions which serve as predicate acts under federal RICO statutes. The specific RICO sections implicated are Section 1341, mail fraud, Section 1343, wire fraud, Section 1344, financial institution fraud, Section 1957, engaging in monetary transactions in property derived from specified unlawful activity, and Section 1952, racketeering. There is the requisite criminal or civil enterprise consisting of the sponsor or issuer, the trustees, and the intermediary bank. These three parties work closely together to effect the securitization transaction. There are predicate acts of mail fraud, using the mails for sending out materials among themselves and to investors. B. Wire fraud, using wires to engage in fraud by communicating with investors. C. Conversion, where there isn't proper title to the collateral. And again, this is something that I've briefly touched on, but people need to do more research on, is the difference between a general and special deposit. A general deposit is a normal carte blanche deposit with the bank where there is neither a title or position of authority by which the deposit is conveyed to the recipient, or it's a special deposit, and a special deposit is considered a trust deposit, where the title to the deposit itself is retained by the grantor. So the trust deposit or special deposit, in essence forms a trust, whereas the beneficial title is then reserved. The interests are reserved for the depositor, and a general deposit is almost in the nature of a general bailment, where there is only a debtor-creditor relationship arising out of the transaction, and that is the type of relationship that these SPVs have essentially gone to defeat. So know what type of relationship you're forming, especially when it results in securities transactions or any financial transactions of that sort. E, securities fraud disclosure issues. F, loss of profit opportunity. G, making false statements and or misleading representations about the value of the collateral. H, stripping the originator or issuer of the ability to pay debt claims or judgment claims in the bankruptcy court. This may apply where the sponsor is financially distressed, and the cash proceeds of the transaction are significantly less than the value of the collateral. There is typically the requisite intent by members of the enterprise, evident in knowledge, actual and inferable, acts and omissions, purpose, actual and inferable, and results. Intent can be reasonably inferred from A, existence of a sponsor that seeks to raise capital, and obviously cannot raise such capital on better terms using other means. B, existence of an investment bank that has very strong incentives to consummate the transaction on any agreeable but not necessarily reasonable terms. Securitization constitutes violations of U.S. antitrust laws. The various processes in securitization constitute violations of U.S. antitrust statutes. These violations are described as follows. Market concentration. The U.S. asset-backed securities and mortgage-backed securities markets are dominated by relatively few large entities, such as Fannie Mae, Freddie Mac, the top 5 investment banks, all of which have conduit programs, the top 5 credit card issuers, MBNA, Amex, Citigroup, etc. Hence, the top 5 ABS, MBS issuers control more than 50% of the U.S. asset-backed security and mortgage-backed security market. This constitutes illegal market concentration under U.S. antitrust laws. Syndicate collusion. The syndicates of investment banks used in distributing ABS and MBS essentially collude to determine A, the price at which each asset-backed security tranche is sold, which investors can purchase different tranches. Collusion occurs because A, in the typical ABS offering, the price determination process is not transparent or democratic because the lead underwriters typically negotiate the offering price with the originator or sponsor and the prospective investors, but some underwriters use auctions. The lead underwriters purchase most of the new issue ABS, and the balance is typically sold to junior syndicate members who presumably can arrange to buy more asset-backed securities from the lead underwriters that then allocated to them. In essence, the true price-demand characteristics and negotiability of junior underwriting syndicate members are very much hidden simply because of the structure of the underwriting and bidding process. Hence, the existing syndicate-based asset-backed security distribution system for a new issue ABS distorts the true demand for ABS, reduces competition, and facilitates and results in collusion and constitutes violations of the Sherman Act and the FTC antitrust statutes. Similarly, the ABS allocation process is not transparent. The lead underwriter and junior underwriters allocate new issue ABS to investors based on subjectively determined suitability and in-house criteria. There is no established or generally accepted major guidelines for such in-house criteria and associated allocation. Price formation. The price of asset-backed securities is often linked to the price yields of U.S. Treasury bonds. The credit risk of ABS and MBS is priced relative to the risk of U.S. Treasury bonds. This system distorts the true demand or supply balance for the ABS or MBS and erroneously incorporates the demand or supply relationships of the U.S. Treasury bond market into the asset-backed security and mortgage-backed security markets. Price discrimination. There are several classes of ABS. 1. Securities that involve pure, quote, pass-through of cash flows, perhaps relating to the pass-through nature of taxation of certain foreign trusts, continuing, and hence rights to payment of cash from the special purpose vehicle pool, but no ownership interest in the pool, to A. interest-only securities, B. principal-only securities, and C. traditional asset-backed securities that pay both interest and principal. 2. Securities that confer ownership interests in the underlying pool, to IO, PO, and traditional ABS securities that pay both principal and interest. And 3. Debt-type securities that involve a security interest in the underlying collateral, and IO, PO, and traditional ABS that pay both interest and principal. In many instances, the special purpose vehicle offers many tranches in each of the above-mentioned classes of ABS. The tranches within each class typically vary by term, interest rate, duration, and bond rating or risk rating. Hence, in any situation where the tranches don't have any priority as to security interests or rights to payment of cash flows from the pool, such stratified offerings within each class, IO or PO or ordinary or pass-through, collateral type or equity interest, constitutes price discrimination because the underlying asset and risk is essentially the same. Although different securities are being offered in the same transaction or series of transactions, at different prices to investors based on the same underlying pool of assets. So they rebranded the same pile of junk bonds into a tranche of essentially the same repackaged securities. A good explanation of this is in the movie The Big Short with Ryan Gosling in his Jenga scene when he explains the ratings of bonds. That's a good movie to illustrate how the tranches and the ABS and MBSs are rated and compiled. Securitization involves void contracts. The process of securitization involves several contracts that are either signed simultaneously or are all signed within a short time frame. Many of these contracts are void and illegal for the following reasons. A. Lack of consideration. There is no consideration in many of the contracts used in effecting securitizations. Many of these contracts are unilateral executory promises and contain illusory promises. There are three main issues. I. Unilateral executory promise. A unilateral executory promise is not consideration. The following are some unilateral executory contracts and securitizations. The promise made by the special purpose vehicle to pay out periodic interest. So these coupons or these payment coupons that are being presented monthly as statements, bond statements with interest coupons attached that are being presented to these principal investors, these original creditors, the consumer, are being advertised as something that pays out interest every month. And they're saying it's an illusory promise. Whether contingent or non-contingent on whether the collateral pays cash interest. Collateral substitution agreement contains a promise in which the sponsor agrees to substitute impaired collateral. Assignment agreement. Assignment of future collateral not yet existing may be deemed a unilateral executory promise by the assignor. Is that an assignment of interest? Because with trusts, you have rights, titles, and interests. Transfer agreement. The sponsor agrees to transfer the collateral to the special purpose vehicle, and that special purpose vehicle in return pays cash to the sponsor. II. Illusory promises. An illusory promise is not a valid consideration for a contract. The following are some illusory promises inherent in securitization transactions. The subscription or purchase agreement. The SPV's promise to acquire the collateral with the cash raised from investors are essentially illusory promises. So they sold an illusion, a dream. Continuing. These promises are embedded in the offering prospectus, but are typically not included other corporate documents. In most cases, the offering prospectuses don't state the exact steps in the SPV's promised purchase of collateral. Purchase or subscription agreement. The SPV's investors purchase beneficial interest in the SPV or the SPV's debt. These beneficial interest evidence A, right to payments from the SPV, or B, an ownership interest in the underlying collateral, or C, a participation in the underlying collateral. However, at the time of executing this agreement, the only consideration that the SPV can grant to investors in exchange for the purchase amount consists of promises to purchase the collateral in the future and to make payments from the SPV's assets. Hence, an existing asset is being exchanged for a future asset that does not exist as of the date of the purchase/subscription agreement. Furthermore, all securitization offerings are done pursuant to, quote, subscription agreements and investor questionnaires. The two documents have to be signed by the prospective investor. None of the agreements signed by the investor as part of his or her purchase of the SPV's asset-backed securities expressly incorporates the promises embodied in the offering's prospectus. What typically exists is an implied agreement to subject the investor to the SPV's articles of incorporation, trust indenture, and/or trustees/board of directors, board of trustees decisions. The SPV's promise to pay interest or dividends on asset-backed securities, interest-only securities, preferred, and principal-only securities are essentially illusory promises because the underlying collateral may not produce any cash flows, in which case there won't be any interest or dividend payments. Sounds like due bills and due checks. Continuing. No bargain. Some courts have held that there is no consideration and hence the contract is void, where one party was not allowed to bargain for the alleged agreement. In some securitizations, the process of setting offering prices for the new ABS issues does not afford all parties the opportunity to negotiate terms of the offering, especially individual investors, consumers, because the price of the ABS is typically determined primarily by the sponsor and the lead underwriters. Furthermore, in securitizations, the originator sets the terms of the SPV, trust documents, articles of incorporation, bylaws, etc. No mutuality. In the securitization context, for there to be mutuality of obligation, A, each party must have firm control of the subject matters of the contract and the underlying assets, consideration, and B, there should be a direct contractual relationship between the parties. At time of the subscription agreement, the SPV typically does not own or have rights to the collateral, and hence there is not mutuality of obligations. Furthermore, the concept of quote, piercing the SPV veil, is introduced here, and is similar to piercing the corporate veil, and applies since the following conditions exist. The economics of the transaction in an asset transfer from the sponsor or originator to the special purpose vehicle investors in exchange for a loan to the sponsor. However, there is no direct contractual relationship. So you have more of a bailment relationship, a general deposit, where the title passes to the depositee, and the depositor loses title to the deposit. Whereas in contrast, a special deposit or trust deposit, clearly indicating the terms of the trust from the inception of the transaction, the depositor retains the title to the deposit, and the use of the deposit is then directed by the depositor. The sponsor typically controls the special purpose vehicle before the asset-backed security offerings and determines or substantially influences the SPV's post-offering operating characteristics. Since prospective ABS investors don't have firm pre-offering control of the SPV and cannot influence its post-offering policies, there is no mutuality between the SPV and ABS investors, and securitization is void. The sponsor influences the appointment of the SPV's trustees or board of directors. Thus, under contract law, the use of SPV in securitization effectively eliminates any mutuality between the two main contracting parties, the sponsor and the investors. Secondly, there is no mutuality between the SPV and the investors. The SPV corporate documents, trust indentures or bylaws, or in articles of incorporation typically limits the rights of each ABS investors and the group of ABS investors. Thirdly, there is no mutuality between the SPV and the sponsor originality, because both entities are essentially the same and are controlled by the sponsor before and after the securitization. Illegal subject matter in contravention of public policy. As explained in preceding sections of this article, securitization constitutes violations of antitrust statutes and federal RICO statutes, and hence, the contracts used to effect securitizations are void and illegal. Conclusion. Under U.S. laws, securitization is clearly illegal. This requires the enactment of special federal securitization statutes and changes in law enforcement patterns and practices. Again, this is going to require further due diligence in regards to procedures, applicability in your local jurisdiction. However, these same principles regarding securitization and the use of trusts and restraint of trade are widely upheld federally as well as in most states, as they violate different jurisdictions and their statutes, and they are clearly fraudulent conveyances. If you found this information and content helpful, please like, comment, and subscribe. Send this to other people that you know. Again, if you'd like to support this content directly, you can do so through Cash App, Venmo, PayPal. There'll be a link in the description to the website where you can find that information. If you'd like to get access to these content materials as well as other law reviews, treaties, how-to guides with regards to trust and estate law, To Be Fruitful Training Group has a private library. Any donations over $50 will receive access as a courtesy. If you'd like assistance with any consultations, again, this is not legal advice, nor financial advice, but if you'd like assistance with your particular situation based on my experiences, I don't charge for the first 30 minutes, but everything thereafter, in 1 hour minimums, I charge $75 just for my time. If you'd like to set up a private trust and you're located within North America, I charge a $200 to get that set up. And anything else I handle on a case-by-case basis. I'd like to thank you all for watching. Thank you so much. Please let me know what you think in the comments. The positive feedback goes a very long way. It really does. I do my best to get back to you and respond to you in a short period of time. Again, thank you so much for watching. I'm very grateful for all of my new and continued subscribers. Thank you so much. Again, all praises and glory to the Most High. This is B with To Be Fruitful Training Group, and we'll see you on the next one. Thank you.